Tuesday, December the 9th, 2014. The time is 10 a.m. It's my pleasure to call to order the State of Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Ms. Lisa Mosley, will you please call the roll?
Robert Helms.
Here.
Wayne Hinkle.
Here.
David Neal.
Here.
W.T. Patterson. Jane Grace Sowell.
Here.
Robert Starkey.
Here.
Anita Taylor.
Here.
Mr. President, we have 6 of the 7 members here.
Thank you, Ms. Mosley. We now have a quorum and we'll continue the meeting as planned. We'll now adopt the agenda for the meeting.
Make a motion, we adopt the agenda as printed.
Second.
Have a motion from Mr. Neal, second from Mr. Hinkle and Ms. Sowell. All in favor?
Aye.
At this time, we have a formal hearing, and we will turn the meeting over to Administrative Law Judge Kim Summers. On the agenda would be the review and approve the minutes from the September 9th board meeting.
Make a motion, we approve the minutes, September 9.
Second.
Okay, I have a motion for Mr. Helms, second for Mr. Hinkle and Ms. Taylor. All in favor?
Aye.
Review the minutes from October 14th.
Motion to approve the minutes for October 14th meeting.
Second.
Have a motion for Mr. Hinkle, or second for Mr. Neal. All in favor?
Aye.
Minutes are approved. Next on our agenda would be our legal report from Ellery Richardson, our Assistant General Counsel.
All right, the first case before you today is case number 2014-020291. Complaint alleges that respondent told the family that the body was not suitable for viewing due to lack of refrigeration, and that none of the establishments in town have refrigeration. Complainant is shocked that the funeral home does not have refrigeration and states that she would have transferred the body to an establishment with refrigeration if she had known respondent did not have it. Respondent states that none of the establishments in the county have refrigeration. My recommendation would be to dismiss the complaint, as Tennessee law does not require establishments without cremation facilities to have refrigeration, and authorize a letter to the complainant stating that the law does not require it.
Motioning to accept council's recommendation.
Second.
Have a motion from Mr. Hinkle, a second from Mr. Neal.
Yes.
All in favor?
Aye.
Motion carries.
Next case is case number 2014-023371. Complaint alleges that respondent lost the body of a baby that was born premature and weighed 1 pound 1 ounce. Respondent states that upon discovery of the lost remains, it immediately notified the mother and undertook an internal investigation, but it was unable to locate the remains. Respondent is communicating with the mother's attorney and is doing what it can, although it realizes that it cannot fully rectify the situation. So the violation would be unprofessional conduct. So the recommendation is a consent order with a $1,000 civil penalty and authorization for a hearing.
Move to accept council's recommendation.
Second.
Have a motion from Mr. Helms, a second from Ms. Sowell. All in favor?
Aye.
Motion carries.
Third complaint is case number 2014-017201. Complaint alleges that respondent ignored the deceased spouse's wishes and followed the wishes of the deceased's children. Complainant states that she called and spoke with respondent multiple times before the cremation and informed him that the deceased spouse wished for cremation through a different provider and had a pre-need contract with that provider, but these calls were ignored. Respondent states that the children told him that the spouse lived in an assisted living facility and was incapable of making decisions due to his deteriorated mental state. He offered to drive to the assisted living facility to speak with the spouse, but the children assured him that the spouse would be unresponsive. The children told him that the deceased had a pre-need policy with another establishment, but the other establishment would not transfer the policy to the respondent. Therefore, the children decided to use respondent for the services, and respondent honored the pre-need prices. Respondent states that the complainant did not contact him until after the cremation, Once he found out that the spouse was able to make decisions and wanted the cremated remains, he coordinated with the children to send the cremains to him. An investigation revealed that the other establishment would not transfer the preneed policy because of non-payment. Additionally, respondent checked no for whether there was a spouse on the cremation authorization form and had the 3 children sign it. The oldest child stated that the spouse suffers seizures and dementia. He often is disoriented and does not know where he is. The investigation was inconclusive as to whether the complainant contacted respondent before the cremation or not. And the relevant statute at issue here is TCA 62-5-708, which is no funeral establishment or funeral director who relies reasonably in good faith upon the instructions of a person claiming the right of disposition shall be subject to criminal or civil liability or subject to disciplinary action for carrying out the disposition of the remains in accordance with the instructions, unless the funeral establishment or funeral director knew or had reason to know that the person did not have the right of disposition. So my recommendation for this case is a consent order with a $500 civil penalty, $500 in investigation costs, and authorization for a hearing.
On the history, has these cases been closed?
Sorry, I don't understand the question.
They still open or are they closed?
Yes, these cases are still open.
All 3 of them are. On the history.
Oh, the history, sorry, all those are closed. My apologies there. All those are closed.
Okay.
Motion to accept council's recommendation.
Second.
I have a motion from Mr. Hinkle, a second from Mr. Helms. All in favor?
Aye.
Motion carries.
Next case is case number 2014-015151. Complainant alleges that respondent conspired with her aunt to disinter her grandfather's remains from a Tennessee cemetery and reinter him in Illinois to reunite him with his wife, who is interred in Illinois. Complainant alleges that this was immoral and unethical for respondent to not contact her or the rest of her family living in Tennessee before the disinterment, and that respondent did not attempt to properly ascertain the next of kin. Complaint also alleges that respondent did not notify the cemetery of the disinterment until after the fact, and respondent took flowers and the headstone, and the cemetery reported the theft. Complaint also alleges that respondent put the vault holding the remains through a car wash. Additionally, complainant states that respondent mailed a death certificate to the aunt years ago when complainant's mother died. Respondent admits mailing this death certificate. Complainant claims respondent violated the laws of the Department of Health by giving her aunt a copy of the death certificate of her mother. The statute allows death certificates to be given to the next of kin. Respondent states that both the deceased's daughter in Illinois and an Illinois funeral home contacted him about disinterment. Respondent states that the daughter asked that he not discuss the disinterment for confidentiality reasons, and he complied with her request. Once he received payment, instructions from Illinois, the disinterment authorization form signed by the daughter, and the disinterment permit from the Department of Health, respondent performed the disinterment on May 29th and 30th. Respondent originally thought that the daughter was going to contact the cemetery, so he did not communicate with the cemetery until after the disinterment, and he apologized for not notifying them earlier. Respondent states he power washed the vault before transporting it. After the disinterment, he learned that there was a second daughter, and he immediately contacted the second daughter to ascertain her authorization. An investigation revealed that the 2 daughters were in agreement to move their father to Illinois to reunite their parents, but the funeral director did not inquire whether there were other siblings with the same right of disposition, and the second daughter did not provide the written authorization until after the disinterment. The cemetery complained that they were not notified but denied reporting a theft. The cemetery also expressed concerns that respondent did not adequately fill in the grave for the disinterment, causing the ground to sink. Respondent stated that he filled in the grave and is willing to correct any remaining problems. The cemetery also states that respondent has not provided a temporary headstone for 3 burials it has undergone at the cemetery, which makes it difficult for the cemetery to keep proper records. Those burials all now have permanent headstones. So the violations at issue are TCA 625703, which I discussed in the previous case, and then 708, which is determining the next of kin for the disinterment authorization. So my recommendation would be a consent order with a civil penalty of $250, $400 in investigation costs, and authorization for a hearing.
The investigation cost is less than the last civil penalty then, is that correct?
Yes, it's dependent, and that's based on the amount of hours our investigators spent on the case.
Okay.
Motion to accept council's recommendation.
Second.
I have a motion from Mr. Hinkle and a second from Mr. Neal, or Mr. Neal. All in favor?
Aye.
Aye.
Motion carries.
Next case is case number 2014-024731. A regularly scheduled inspection revealed that respondent cremated a deceased without a cremation authorization form that has not been submitted for approval and did not have a funeral director's signature. Another deceased was cremated without the authorizing agent's signature on the form. Respondent did not use a permanent identification device for 2 cremains. Respondent was also cited for failure to properly maintain its crematory log. Specifically, respondent did not fully fill in the log to include date of release and manner of final disposition for 21 cremations. And the respondent did not respond to the complaint. The recommendation is a consent order with a civil penalty of $1,500 and authorization for a hearing.
You add $250 for not responding?
Yes, I did.
Okay.
Motion to accept.
Second.
Have a motion for Mr. Helms, a second from Mr. Hinkle. All in favor?
Aye.
Motion carries.
Case number 2014-024971. Complaint alleges that respondent took too long to cremate and ship the remains to the family in North Carolina. Respondent states that the deceased passed away on August 23rd. Respondent spoke with complainant 4 days later and faxed the cremation authorization form to her and told her that they would start the cremation after they received all the necessary paperwork and payment. The health department did not issue the cremation permit until September 5th, and the cremation was performed on September 6th. Respondent was not able to get in touch with the family until September 10th. Respondent mailed the cremains that day, and they arrived on September 12th. The family received the cremains 20 days after death. My recommendation would be to close this complaint.
Motion to accept.
Second.
Have a motion from Mr. Hinkle, second from Ms. Taylor. All in favor?
Aye.
Case is case number 2014-025281. Complaint alleges that respondent's website lists 5 unlicensed individuals as morticians and has a photo of an unnamed individual. Respondent states that it had just launched its website a few months before the violation was noted, and once it was brought to their attention, they immediately removed the mortician references. My recommendation would be a consent order with civil penalty of $250 and authorization for a hearing.
Motion to accept council's recommendation.
Second.
Have a motion from Ms. Taylor, a second from Mr. Hinkle. All in favor?
Aye.
Motion carries.
Next case is case number 2014-025301. Respondent's establishment license expired on January 31st, 2014, and was not renewed until March 13th, 2014. Respondent cremated 78 individuals during this time. Respondent apologizes for the oversight and states that it corrected the licensing issue as soon as it was discovered. My recommendation would be a consent order with a civil penalty of $1,950 and authorization for a hearing.
Motion to accept.
Second.
Have a motion from Mr. Neal, a second from Mr. Hinkle. All in favor?
Aye.
Aye.
Motion carries.
Next case is case number 2014-025331. An inspection revealed that 2 cremation authorization forms were missing and 7 cremation authorization forms were not dated by the authorizing agent. Respondent states that they have located the 2 missing forms and they have given us a copy of those forms and have gone back and corrected all the cremation authorization forms to add the date and have ensured that this mistake will not take place again.
Motion to accept council's recommendation.
Second.
Have a motion for Ms. Taylor, a second for Mr. Hinkle. All in favor?
Aye.
Motion carries.
Is case number 2014026441. Complainant bought the establishment and goodwill of respondent's formal funeral home and subsequently, formal funeral home I'm going to call X just for clarification purposes, and subsequently changed the location and name. Complainant alleges that respondent opened a new funeral home and in advertisements calls the new establishment formerly X Funeral Home. As the purchaser of X Funeral Home, complainant alleges that this is misleading and deceptive. Respondent states that they do not intend to be misleading, and the purpose of the statement is to let members of the public know that their location is the same as the old X Funeral Home. My recommendation is a consent order with $250 civil penalty and authorization for a hearing.
Sound like somebody should have had a no-compete clause. Motion to accept.
Second.
Have a motion for Mr. Hinkle, a second for Ms. Taylor. All in favor?
Hold it.
Yep.
What is the violation?
The violation is misleading advertising because it's stating that the funeral home is formerly X Funeral Home, but the complaint bought the establishment and the goodwill. And so they're just using the same location, which is not the same business.
Change the location.
Complaint bought the business and the goodwill and moved the location. And then the allegation is that by the respondent opening a different business in the same location and saying it is formerly X business, it makes it seem like they have just changed the name and it is the same business when in fact it is a different business.
In other words, you sell your funeral home to me, and I move it to a new location, but Robert opens a new funeral home and calls it the former funeral home. So we got really 3 people involved here instead of 2, right?
Well, there are actually just 2 and not 3. So you bought it from me, and then I open up a new one and say it was formerly the one I sold to you.
Okay, all right.
Would the board like to keep the civil penalty it voted on, or?
They purchased the business, which means the goodwill of the business.
Which does include this former name.
Yep.
Mm-hmm.
But change the name.
It did change the name, yes.
But the advertisement is intended,
But now
as I interpret it, to let the people know that
the group that says it was formerly X Funeral Home is not the group that bought the establishment. It's the one who sold it, so it's a little confusing.
I am confused.
I look at it as just as an information advertisement and not someone trying to deceive somebody. I don't really think it's a funeral issue.
If the board doesn't think that is misleading or deceptive, it can change its decision.
Now, I'm interpreting though that I sell my funeral home to you, and you bought the name and everything, and then you moved to a new location. But then I reopened it and said I'm the old funeral home. That is deceptive.
That's deceptive.
So is that what you're saying?
I didn't get that in there.
Yeah.
Yes, the President is correct. I'm sorry if my explanation was a little confusing.
Yeah.
That's why I said something about a no compete clause.
To get back in. Okay, I didn't understand that. Okay,
Yeah.
all right.
Was the board content with leaving that case on its former motion?
Yes.
Yeah.
All right. The next case is case number.
Whoa.
Wait, I don't
We need to
think
vote.
we
We need
had
to
a
vote.
question, so we.
Oh, do we
Yeah,
never
we
get
need
around
to
to
vote
voting?
on it.
Okay.
All in favor?
Aye.
Aye.
Aye. Motion carries.
Okay. The next case is case number 2014-026-801. Complaint alleges advertising in violation of TCA 62-5-314. The advertisement shows a photo of its staff and does not disclose whether the individuals are licensed funeral directors or not. Respondent admits that the advertisement did not have the proper disclosures, but states that the newspaper did not give them a proof of the ad for them to approve before it ran, as they had requested. Respondent submits proof that it told the newspaper to include the disclosures. The newspaper states that it accidentally ran the ad a week before it was supposed to run, did not send complainant a proof, and admits that it left the disclosure off by mistake. This respondent has a history of advertising violations, but based on the facts, my recommendation would be to close because it seems to be clearly an error of the newspaper.
One of the first complaint advertising the $250 civil penalty, have they paid that?
Yes, they have.
Okay.
Motion to
So
accept.
they've got a letter of caution and they've got a letter of warning that's been sent to them for basically the same stuff.
This is a repeat issue with this respondent, so if the board wishes to change the recommendation, they can do so. That was just my recommendation based on what the newspaper sent us.
I'd make a motion to accept your recommendation based on the fact that, and we've had this come up before with Yellow Pages, the newspaper, if they get a chance to run something, they'll run it without proof. Motion to accept council's recommendation.
Ms. Taylor's already got that on.
Oh, well, I'm sorry. I can second it, I'm
Okay,
sorry.
yeah. We have a motion from
getting
Ms.
carried
Taylor,
away
and a
here,
second
Dave.
from
I'm
Mr.
hungry.
Hinkle. All in favor?
Aye.
Motion carries.
We get done here and go eat.
Next case is case number 2014-025-071. An inspection revealed that the establishment license expired on April 30th, 2014, and was not renewed until May 27th, 2014. Respondent handled 2 cases during this period, and respondent did not respond to the complaint. So my recommendation would be a consent order with a civil penalty of $350 and authorization for a hearing.
There's $250 in there for not responding.
Yes.
Okay.
And what the board has generally done before has been $50 per unlicensed incidents.
Move to accept.
Second.
Have a motion by Mr. Helms, a second by Mr. Neal. All in favor?
Aye.
Motion carries.
There is one more case. It is case number 2013-000-591 and 2013-000-592. Respondent was arrested for aggravated assault and reckless endangerment over a domestic incident. Case was previously put into litigation monitoring status. On September 3rd, 2014, the judge dismissed the case and agreed to expunge respondent's record. So therefore, my recommendation would be to close with a letter of warning.
Motion to accept council's recommendation.
Second.
Have a motion, Mr. Helms, excuse me, for Mr. Hinkle, second from Ms. Taylor. All in favor?
Aye.
All right, next thing on the agenda would be Robert Gribble, our Executive Director in Administrative Matters.
Thank you, Mr. President. First thing is the licensee report. This is a report of license administratively approved by the Executive Director pursuant to the Board authority for the period of October 14, 2014 through December 8, 2014. And you have a list of the establishments affected there and also the individuals. Next would be the closed establishment report for December 9th board meeting today. We have 2 establishments that have reported closing since the last board meeting. That's Grace Funeral Home in 12 Buchanan Street here in Nashville, and Serenity Funeral Home and Cremation Center, LLC, in Cleveland, Tennessee. Next item is a disciplinary action report. This is a report of consent orders administratively accepted and approved by the Executive Director pursuant to the Board authority, period of October 1st, 2014 through November 30, 2014. You have a list of those that furnish those by a separate email as well. I have to report to you today is the open complaint report. As of yesterday, we had a total of 47 complaints, 1 against an apprentice, 6 against either a funeral director or an embalmer, and 40 against an establishment. Mr. President.
Gribble?
Make a motion we accept.
Second.
I have a motion from Mr. Neal, a second from Ms. Taylor. All in favor?
Aye.
Motion carries. Next on the agenda will be approval of license applications. Individuals.
President, you have one individual today. It's James O.T.H. Mitchell of Bardwell, Kentucky, who has applied as a funeral director and embalmer by reciprocity from the state of Kentucky. This gentleman has met all the requirements. The reason well, first of all, he is not personally before you today because he lives some three hours away, and he and I had a phone conversation yesterday, and it was going to be necessary to take off work and come today, and he needs to be there at work. So I told him I'd present his application to the board. He, 5-year, since he doesn't have an associate degree, I could not administratively approve it, but he does show proof of working more than 5 years prior to license.
He meets all the requirements.
Requirements, provided you all agree that it's not necessary for him to have the associate degree, and he meets the requirement of 5 years. And
Yeah.
there's ample evidence to indicate that he's been licensed much more than that, and he has worked as a funeral director.
Motion to accept.
Second.
I have a motion from Mr. Hinkle, a second from Mr. Helms. All in favor?
Aye.
All right. Next will be establishments.
First establishment to come before you today is Nashville Cremation Center, 8120 Sawyer Brown Road, Suite 108, Nashville, Tennessee, 37221. Establishment, the ownership is a corporation. The owner is LM Enterprises Incorporated, located at the same address. Mr. Jeff Murphy and Mr. Wayne Perry speak to you concerning this application. Gentlemen, would identify your names for the record, please, and whatever statement you want to make to the board, go ahead and make your opening statement.
My name is Jeff Murphy, and I'm a funeral director and embalmer in Wayne.
My name's Wayne Berryman, and I'm a licensed funeral director.
We, as you see, we're applying for an establishment license to open a funeral and cremation provider office in Bellevue. This will be an alternative type business. It is located in an office park, condo office. The embalming, cremation, backroom services will be provided by our other business that we own, Music City Mortuary in Nashville. The location of the new business is we bought the condo, we own it, it's not a lease, and we respectfully ask the board to approve our application.
You have ample amount of parking then, don't you?
We have quite a bit of parking.
Doing about signage.
There is a marquee sign on the roadway and with the other businesses there, so we'll have a sign there. And then on the outside of the door, there's a bronze plaque that'll be placed there.
Looking building. Will they meet the requirements?
Writing the board believes they do, yes, sir. They've responded with all the requested information.
Motion to approve.
Second.
Motion from Mr. Hinkle, a second from Mr. Neal. All in favor?
Aye.
Aye.
Motion carries. Congratulations. No. Call the roll, Ms. Mosley. Thank you.
Robert Helms,
Yes.
Wayne Hinkle,
Yes.
David Neal,
Yes.
Jenny Gray Sowell,
No.
Robert Starkey,
Yes.
Anita Taylor. Mr. President, you have 5 out of the 6 with yes and 1 no.
Motion carries. Congratulations.
Thank you, gentlemen.
President, the next is Cremation Society of Tennessee, LLC, 2014 Elmer Pug Drive, Suite 102, Columbia, 38401. It's a change of location application. Ownership's a LLC, and it's Cremation Society of Tennessee, located at 2517 Trotwood Avenue in Columbia, Tennessee. I don't think they have a representative here today. My recommendation is you table this till the next month. We've been in communication with them. Probably like for a representative to be here to answer your questions. I'll just say that from what the field rep said, and you can look on your iPad there if you want to and read his email. When he did the inspection, he the entrance was located to the rear. It's from the rear of the building, and that one room. The only area that would be occupied by this proposed or this establishment in this proposed new location. It's located on the first floor of the building, and there would be shared restrooms with other building tenants located in adjacent hall. That's your prerogative. If you want to act on it, that's fine. But we did talk with them yesterday. One of the people we've been talking with is out on sick leave, and they had informed Ms. Mosley they had training today to attend to, and that they most likely would not be here.
Make a motion, we table it to the next meeting, next scheduled meeting.
Second.
Have a motion from Mr. Hinkle, a second from Mr. Helms. All in favor?
Aye.
Aye. Does that conclude the establishment report? Okay. Next on the agenda is election of board officers for 215.
Motion to elect Miss Anita Taylor as president for next year. I
I'm
withdraw.
sorry, I was distracted reading the prior thing that something was in red and I didn't hear that. I move to, my acclamation to reelect Mr. Starkey as president and Ms. Taylor as vice president.
That,
Is that suitable?
suit you?
Is that suitable?
Yes, yes, yes. No. I'll pass.
All right, all right, okay. I have a motion and from Ms. Al. Do I have a second?
Second.
Oh, a second from Mr. Neal. All in favor?
Aye.
Thank you. Okay, the continuing education liaison for 215.
I make a motion that Mr. Starkey be education liaison for next year. And that's the duties you've been fulfilling anyway, isn't it?
No,
No.
no, that's Ms. Sal.
Miss Alvin,
She has done a great job.
we got,
You want to withdraw that one too, Mr.
I'm
Taylor?
going to withdraw my motion again.
I move that we elect or nominate Ms. Jane Grace Sal as the continuing education liaison.
I will accept, except somebody else wants to do it. That's fine. It's just a matter of signing a lot of documents. That's all it is.
But you're willing to do it?
Yes.
Second.
I have a motion from Ms. Taylor and a
Second
second
from me.
from Mr. Neal. Okay. All in favor?
Aye.
Congratulations.
Congratulations to you. Y'all both have done such a good job. That was
That was easy, wasn't it?
Do we have any new business to come before the board? I'll accept a motion for adjournment.
So move.
Second.
Have a motion from Ms. Taylor and a second from Mr. Neal. All in favor?
Aye.
Meeting is adjourned. Thank you, everyone.